And that's all I have for this. We're going to go back to Mark for a second.
So we're moving to a new segment. This is the part about the healthcare power of attorney. Vincent Angermeyer and I are going to be doing this for you. And our thinking here was, because of COVID, this is a document that's actually likely to come into play for some of you. It's often the first document that you start working with in your estate planning portfolio. So what we want to do is understand how your power of attorney for healthcare is set up. And for those of you who don't have a power of attorney for healthcare, you'll want to get this done. So we'll talk a little bit about how it's done properly, what can be in there, and then I will talk about the practical side of things. So I'm going to turn this over to Vince right now.
So before we can really talk about how it works, we need to make sure we're using the right terms, because I think in day-to-day life, a lot of expressions for living wills and advanced directives get thrown around. But because we're lawyers, it pays to be precise about what we're talking about. So a living will is the guidelines for what you want to happen in terms of decisions that have to be made when you're not available to make them. And the healthcare power of attorney designates who the guidance is for, who's going to be carrying out what you want. And then when you combine the two, they're advanced directives. Advanced directives apply to the group. Now, if you look through your binders, you won't find a living will. That's because we have an article of the healthcare power of attorney, Article 3, that really functions as a living will. Now, in terms of effective planning, you need to have clear directions. Obviously, if the point of the document is to simplify decision making for people, you need to be clear what decisions you want them to make and what the parameters are. So obviously, it needs to be clear who the agent is. In fact, and in terms of, and also who the successor agent would be if a primary agent isn't available. It needs to be clearly identified. Who are you talking about? Where are they? Obviously, usually full name is good enough. So that if the person goes to the hospital can confirm who they are and start listening to them. And relatedly, it needs to be clear exactly what the agent can and can't do. It can be customized. This is a highly tailored part of the package you get. So if you want them to carry out decisions related to refusing to treatment or discontinuing treatment, which can go so far as checking you out of the hospital if, consistent with your wishes, you wouldn't want to continue being treated there, or you want to move your treatment to somewhere else. It's a big decision, but it's still something you can assign to your agent. Same thing with hiring and firing medical personnel. If that's a decision you could or would make if you were capable of making it, that's again another thing that can be passed on to your agent. And it doesn't need to be a life-threatening scenario. If admission to a nursing home, that's obviously, or in many cases, that's going to be a decision where by the time it needs to be made, you might not have the capacity to make it in the opinion of your doctors. And so at that point, it'd be good to have an advanced plan in place for who's responsible for making that decision and what kind of guidance have they been given in terms of what to look for when making it, and also where to send you. And then relatedly, just as a last thing, and this would be a basic part of most plans, is being able to get medical information. We keep your information confidential, and unless somebody comes to us with signed documentation from you, we're not sharing it with anybody, because that's our duty of confidentiality. And hospitals have the same thing. They're going to be pretty limited in who they're willing to share medical information with until they have something in writing from you, giving clearance. Now, just like the identity of the agent can be tailored, so can the guidance. And so in most cases, in most of your plans, there'll be a general expression that you do want to be kept comfortable, and that to some degree, you don't want to prolong the inevitable. Although, in working with us, you will have kind of tailored out exactly what you mean by prolonging the inevitable, or what kind of opinions need to be gathered, or how much time you're talking about. And that can be further, the default is prolong as long as possible, but obviously there's an escalating series of measures you can take to shorten that. So if you have entered a permanent vegetative state and permanent loss of consciousness, if your healthcare power of attorney is giving direction to your agent to, have that be a trigger where, you might have a do not resuscitate in place or a no code. That can be in there. And I'm sure your agent would appreciate having that kind of guidance and not feeling so much weight because they know what you want. Same thing with a terminal condition where you might still be around, but your agent can still help you with the decision making, or if there's a crisis moment, can act on it. Similarly with severe dementia, and by severe, we don't just mean, having trouble with directions or having trouble with word finding. I mean, that we're really talking about the degree to which you might not be recognizing family members anymore. Again, that's a situation where the family members, if they're your agent, might really benefit from some guidance from you. And then really about as far as the plans can go would be where you reach a point where quality of life is unacceptable. It's not quite life-threatening, but because of your personal preferences, and this isn't in most of the plans we make for clients, you can still put in do not resuscitate and no code orders if say you become fully paralyzed or if you're otherwise bedridden and things like that. That needs to be a discussion. That's something we would really want people talking to us about and really thinking through, because it is only in some of our plans, and we really do ask that it be fully thought out before that goes into the plan. And with that, I'll turn over to Mark.
So what we're trying to do is tell you what the technical side of your document looks like, why these things are in there. But many of you know that we also speak about the importance of having things be practically effective. So we're going to talk about how things work in the real world and some of these things that aren't so technical or legal. The first thing is how do you pick a healthcare agent? So those of you who are our clients already know that we've helped you through this process. Some of you in the audience haven't gotten your estate plan done, so you'll learn a little bit about how we'll help you approach this. Well, we often, if we're going to name a healthcare agent, somebody who's going to stand in our shoes making healthcare decisions for us, you want somebody who's close to you, and those are your relatives. It's going to be your spouse, your adult children. It might be your brother or sister, but those are the people that are going to know you and care about you. But when you're picking an agent, you also want to make sure you have somebody who's actually going to follow the guidelines that Vincent just mentioned about terminating healthcare that's not going to help you get better if you're in a coma or suffer from severe dementia. And so some people get a little squeamish, and so you want somebody who is going to have the strength to say, I think it's time to say no more care at this point. Distance is a factor, meaning how far away is your agent? If they live in California and you're here and you're in the hospital, sometimes being physically present is an important thing. But we do want to pick the son or daughter, brother or sister who's going to make the best decisions, but distance is an important factor. The phone can be a practical alternative, and we do mention in the documents that we prepare that either communication from the agent by phone or fax is acceptable. Let's go to the next slide. More practical tips. This is, even though you're going to be setting out guidelines in your document, it's important to talk to your family about what you have in mind so that they, again, feel comfortable when they're having to act under this document at a time when we probably can't communicate very well with you. We want to make sure the healthcare power of attorney as a document is where we can get at it. I always tell clients when they come in now that because this has been my experience, every time something bad happens to you medically, it's Friday or Saturday, and you can't get a hold of your doctor and much less a copy of the healthcare power of attorney. So we make paper copies when we do a plan. We get it to your primary care doctor and specialists. We want to make copies for your agent and encourage you to pass those out. We want you to keep it in your car. Just in case somebody is driving to see you, they'll have a copy of the healthcare power of attorney. If you've got a second home, a vacation home, or you're a snowbird, you want to keep a copy in both locations. And then for those of you who haven't gotten a plan done, I know you can go on the internet and take a look at the forms, the free forms that are available, but I can't stress this enough how important it is to get counseling, to get some advice on how to fill that form out, what boxes to check on those forms, and what guidance that you might want to leave about these end of life issues. If they're not worded right, it can create a horrible mess. So again, please get some counseling on that. And then last but not least, we've got some tips for snowbirds. Those of you who are smart enough or lucky enough to be able to get out of here when it gets cold. Typically, most people are heading to Florida and Arizona. And we think even before you leave, if you're going to spend a lot of time in one of those locations, that it might be a good idea to have us draft an Arizona or Florida healthcare power of attorney. And again, it's a practical issue. Legally, the document that you've done up here is valid, but try to convince the clerk at the front desk at the hospital you're checking into in Florida. They're not going to be sure. They haven't seen one that looks like yours before. Oh my gosh, it's talking about Wisconsin law. What do we do? And so it'll get kicked upstairs to some legal department, and it'll just slow things down. So in order to speed up the process, we just draft a power of attorney that looks familiar to the local folks. So those are the practical steps that we take in order to get that power of attorney actually effective for you. And now we're ready to move on to one of my favorite subjects, and that's divvying up the pots, the pans, the furniture, the jewelry, the clothing. And for this, we have our friend Roman Hoynatsky.
Did you want to talk about anything COVID specific for HCPOAs?
Mark, are you going to respond to something first, or do you want me to take up?
What did you want to say, Vince? Go ahead and just say it.
Well, I think we had added, we were going to talk slightly about how COVID ties into all this. I think it was supposed to be in my part, and then I tossed it over to Mark without talking about it. Now, obviously, HCPO healthcare powers of attorney are more relevant because of COVID, because it's a new reason you might end up in a hospital. But we all know that already. The real issue, especially for people who don't have one yet, is that HCPOAs are one of the hardest forms to get completed properly in Wisconsin that there is. It's up there with wills in terms of the requirements for who signs it, because there's limits to who can sign it. You cannot have family members or anybody who stands to inherit from you be a signatory to your healthcare power of attorney. And none of your doctors who are providing care can sign it. So that can be an issue if, somebody who's not fortunate enough to already have an HCPOA in place ends up in the hospital due to COVID, because their doctors, who are probably the only people in the room, cannot be signatories. And maybe in the past, you could have snuck in a janitor or something like that to be the signatory. They're probably not going to do that anymore. And it's going to be harder than ever for family members to get in to take care of it, especially if they don't have an HCPOA in place, but especially because of the contagion factor. So more than ever, this really needs to be thought out in advance. And it's also for people who are already in advanced care facilities that are in lockdown now. You really need to be making plans well in advance about how you're going to get people in there to serve as a witness to this. And even though, more and more things are being done remotely now, and some practices or, say real estate signings can happen remotely or be notarized, over webcam and things like that. That's not the case in Wisconsin. The law doesn't allow for that, and the regulatory agencies really have made a conscious decision to not let signings happen remotely or by webcam. So in addition to being more important than ever to have them, it's really harder than ever to get them completed in compliance with state law. And so if you know anybody who might not have these documents in place, or if you yourself have updates that you want for your power of attorney, it really pays to think ahead now more than ever. And that's all. That's it. Sorry, Roman.